Good day, Crime Talk aficionados. We have another great show for you today. Well, guess what? Bryan Kohberger's guilty plea paperwork has been disclosed, and it shows mental health diagnosis. And, let's say it's sparking a little bit of doubt in some people's minds. Closing arguments delivered in the Donna Adelson murder trial ahead of the jury deliberations. The wife of accused Kentucky sheriff denies any relationship between the daughter and the judge. A married educator stares down a couple of decades behind bars after admitting to a little romantic escapade with a pair of pupils. An elderly man charged with murder of his wife because he just couldn't take it anymore. We have this day in legal history. Our quote of the day has to deal with the purpose of the law, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reisch, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get started, let me remind you, go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you'll be able to do a background search on anyone here in the United States, and as many people as you would like to in the United States. And the report is literally prepared while you wait. It's emailed to you, and you can even get updates, and you're going to get information regarding cell phone numbers, social media presence. You're going to be able to find out email addresses, phone numbers, and you're going to find out if they have a criminal history. Are they married? Are they divorced? Do they have judgments, liens against them? Everything you want to know about somebody coming into your life, or maybe making the decision of whether they need to get out of your life. So go to crimetalksearch.com. All right, ladies and gentlemen, before we get to the docket, one more reminder, a little public service announcement. If you're in Denver or you're coming to CrimeCon, that's going to be in Denver, we are going to be there. It begins Friday, Saturday, and Sunday. We have set up a little booth, going to have a little giveaway for everybody that comes by. Only thing you have to do is show that you're a subscriber and you get free stuff. How about that? So come check it out. It's at the Gaylord Hotel, and we got a great spot right in the middle of the room. I can't wait for you to come by and say hi. Look forward to meeting everybody. It's going to be great. All right, let's go ahead and get to the docket today, and let's open the record for Thursday, September 4th, 2025. And first, yes, Bryan Kohberger, obviously convicted of the 2022 murders of the University of Idaho students, disclosed in some handwritten court filings that he had been diagnosed with not one, not two, not three, but four mental health conditions. Now, the document that has been unsealed following his sentencing to his life imprisonment also highlights his decision not to provide any explanation for his actions. Now, this 9-page guilty plea advisory signed by Kohberger on June 29th was released by Judge Hippler. And in it, the 30-year-old former criminology PhD student indicated that he was diagnosed with level 1 autism, obsessive compulsive disorder, attention deficit hyperactivity disorder, ADHD, and avoidant restrictive food intake disorder, ARFID. Well, if we had known all that, we did. Well, bygones, right? No, doesn't matter, doesn't provide any excuse under the law. Anyway, these assessments occurred back in February 2025 during the evaluations by the defense experts ahead of trial. Now, Kohberger's legal team had obviously previously attempted to use these diagnoses to argue against the death penalty, citing his level 1 autism as a factor warranting leniency. They also suggested that his OCD explained certain behaviors, such as his frequent hand washing and glove use, and contributed to sleep issues that influenced his initial alibi of stargazing on the night of the murders, an account he later retracted upon pleading guilty, obviously. Additionally, court records noted that Kohberger's history of an eating disorder consistent with the ARFID, alongside a report drastic weight loss during high school and a past heroin addiction. Now, the document confirmed that he was not on medications for any of these conditions, but was prescribed levothyroxine for hypothyroidism. In the filing, Kohberger affirmed his understanding of the proceedings and his plea agreement, which resulted in 4 life sentences for first-degree murder, and let's throw in another 10 years for good measure for the burglary. When prompted to share any further reasons for his guilty plea, he declined. During sentencing on the 23rd of July, he also chose not to address the court or the victim's family, leaving the motive still undisclosed. Prosecutors have stated that no direct link was found between Kohberger and the victims, who were stabbed to death in their off-campus home in Moscow, Idaho. Now, Kohberger was arrested, obviously, at his parents' home in Pennsylvania in December of 2022, and that was because linked to the crime via DNA on a knife sheath located at the scene. He is now serving his sentence at the Idaho Maximum Security Prison, and he's agreed to waive all of the appeals. Now, the revelations of Kohberger's diagnoses has drawn some criticism through social media, where people are questioning their validity and their timing. Of course, ladies and gentlemen, he didn't have any of these diagnoses until he needed it for court. That is not uncommon. Let's not be naive, all right? The attorneys said, oh my gosh, look at this. Come up with something. It's part of the process, or it's part of the game, if you will. All right. It's called mitigation. That's why I think I mentioned the other night on our live show, talking with attorneys. The whole practice of law has changed so much from when I started. Before it was like, hey, are you guilty? You want a deal? You want to go to trial? Let's go to trial. And you went to trial all the time. Now everybody's in this mitigation thing where you got to come up with 20 different reasons why, somebody had a crappy childhood, and you come up with it and explains why it is. Okay, it may explain why, but it's not an excuse as to what they did. And don't get me wrong, I've heard some real tragic stories, and it's persuasive. It can be. But when you're grasping for straws and says, oh, we got OCD order. Oh, okay. Well, does that excuse going to stab 4 people to death? Absolutely not. But you get into this almost mitigation fatigue. I think prosecutors get into that mitigation fatigue as well, where they're like, I've heard it all before. Are you kidding me? Anyway, so like I said, some people are describing these claims as convenient, arguing they undermine the genuine mental health discussion without excusing his actions. Some people have noted that they have similar conditions, but emphasized personal accountability, while others insist that the diagnoses don't mitigate responsibility for the crimes. Anyway, the reality of it is, I thought this was worth noting, because there's so many people that are still these pro-Kohbergers who think that he is innocent. I don't understand it. I have said he pled guilty. That's the ultimate confession. And here you have it in his own handwriting. When you look at the documents, he filled it out. He signed it. Although he has handwriting of a 5-year-old, literally. I know they don't teach cursive anymore, but the reality of it is, it looks like he's scribbling like a 5-year-old. It's in his own words, ladies and gentlemen. It's in his own handwriting, ladies and gentlemen. It is the ultimate confession. He doesn't have to give a reason why he did it, just that he did it. So a little further insight in regards to Kohberger's state of mind emerged also as we learned the digital forensic analysis. Jared Barnhart, an expert from Celebrite, reviewed phone data indicating that old Kohberger was suffering from a little bit of paranoia before his arrest. Searches related to altering his vehicle's appearance, suggesting awareness of police scrutiny following the identification of a suspected car. And though DNA evidence ultimately confirmed his involvement in the case, he didn't seem to be too worried about it. Well, maybe just a little bit, because he knew he lost his knife sheath. Well, anyway, as things will be released, we'll bring it to you. A lot more documents were unsealed. We brought that to you yesterday as well. And as we finally get those, we'll talk about them. Next, closing arguments delivered in the Donna Adelson murder trial. That's right, the trial of Donna Adelson, accused of the 2014 murder of the Florida State University law professor Dan Markle, entered its 12th day in Leon County Circuit Court, making what may be the final phase before a verdict. Both the prosecution and the defense presented their closing arguments, after which the jury is obviously going to begin deliberation. A decision on Adelson's guilt could emerge as early as today, or could take as much time as they need, could go in the next week. It just depends on the jury. There is no stopwatch or time limit on jury deliberations. Now, Miss Adelson, who's 75, faces charges of first-degree murder, conspiracy to commit murder, and solicitation to commit murder. Prosecutors allege that she played a central role in orchestrating a murder-for-hire plot that resulted in Markle's fatal shooting in his Tallahassee driveway. The incident stemmed from a contentious custody dispute between Markle and his ex-wife, Wendy Adelson, Donna's daughter, who sought to relocate their young sons to the Miami area. And obviously, this is the fifth prosecution linked to Markle's death, following convictions of 2 hitmen, an intermediary, and Donna's own son, Charlie Adelson, who was found guilty in 2023 after a brief jury deliberation in that particular case. So the district attorney opened her summation in closing arguments by displaying a photograph of Dan Markle to the jury, emphasizing his role as a professor, son, friend, and devoted father. And she countered the defense's portrayal of Markle as inept during the divorce, describing him instead as a Harvard-trained lawyer fiercely advocating against his children's relocation. Well, the district attorney highlighted the non-negotiable nature of the custody issue for both parties, stating that Markle's sole offense was in an unyielding fight for his sons. She pointed to Wendy Adelson's statements to investigators, which implicated her family as having the strongest motive against Markle. The prosecutors depicted Donna as a controlling figure who micromanaged her daughter's life and relied on Charlie to execute her directives when obstacles arose. Now, drawing on testimony from Robert Adelson, Donna's estranged son, the prosecutors illustrated Donna's inflexible expectations and the consequences of noncompliance. Emails from Donna were cited, revealing her insistence on relocation as essential and her derogatory characterizations of Markle. The prosecutor refuted defense claims that Donna was unaware of the relocation denial, presenting evidence of her continued efforts, including proposals to baptize the children or offer Markle $1 million as a buyout. Well, the argument traced communications linking Donna to the plot, including her role in updating Charlie on divorce developments. The prosecutor connected these to Charlie's solicitation of an accomplice shortly thereafter, and she dismissed the defense depiction of the divorce as amicable, noting references to underlying drama in the family correspondence. Now, key evidence included coded discussions, such as a purported birthday gift for Donna's husband, interpreted as the murder, and a timeline of phone records tracking the hitman's movements. Post-murder behaviors were scrutinized, including Wendy's lack of concern upon seeing police at Markle's home, and financial transactions to an intermediary allegedly signed by Donna. The prosecutor addressed the family's response to an undercover FBI operation where Donna received a demand for money. She argued that Donna's coded phone conversation with Charlie about a $5,000 TV, unmentioned by the agent, indicated guilt. An innocent individual would not communicate in such a manner. The prosecutors dismantled Charlie's prior extortion defense, noting inconsistencies in their actions if truly victimized. So, following arguments, the judge instructed the jury on the charge, outlining the elements the state must prove beyond a reasonable doubt for the convictions of first-degree murder, conspiracy, and solicitation. He emphasized the presumption of innocence, the requirement for a unanimous verdict, and the decision must be based upon evidence, not emotion or sympathy. The judge also reminded the jurors to evaluate witnesses' credibility independently and noted that Donna's decision not to testify cannot imply guilt. Notably, Adelson waived consideration of the lesser included offenses. A defense request to admit full calendars into evidence containing Markle's license plate details was denied, though portions were allowed as demonstrative aids. Anyway, the judge reiterated courtroom decorum, rules prohibiting expressions of approval or disapproval during the proceedings. And the jury consists obviously of 12 people, which is made up of 8 men and 4 women, plus 2 alternates who have attentively followed testimony, including recorded conversations and experts' analysis. Deliberations will commence without sequestration plans, and obviously their duration remains uncertain. Now, the defense concluded its case on September 3rd without calling Donna to the stand, despite repeated inquiries from the judge whether she would do so. Adelson confirmed her choice to remain silent, contrasting with Charlie's testimony in his trial, which preceded his swift conviction and life sentence. Throughout the proceedings, the defense sought to undermine motive, question family dynamics, and highlight alternate suspects. However, the focus now shifts to the jury's assessment of the evidence presented over nearly 2 weeks. Obviously, this is a protracted legal aftermath that has taken place for Markle's murder, with implications for family accountability in a high-profile custody dispute. Just think, had they not done what they are alleged to have done in this particular case, referring to Miss Adelson, guess what? Those kids would have both their parents, and they probably could have worked through their issues. But no, they had to go do that. But a couple of observations here. First, best thing was for Adelson not to testify. Good choice. Always won more trials when the defendant doesn't testify, because the jury looks at all the evidence or the lack thereof. And when the defendant testifies, the jury kind of throws all that out, and then they simply focus on, did we believe the defendant? You know, oh, look, he had beady eyes. We don't like him. Find him guilty. All right. Best thing a defendant can do, unless, of course, you have to testify like in a self-defense case. The other thing I like about the Adelson thing, and I don't know if it'll work, is they didn't want any lesser charges. It's first-degree murder or nothing at all. It doesn't matter, right? She's almost 80 years old. What's it going to matter? She's either going to go home or she's going to go die in prison. And what does it matter whether it's manslaughter, criminally negligent, second-degree murder? I like the choice. Make them choose first-degree murder. I like it. Or conspiracy. Or solicitation. Don't go for the lessers. Lessers are kind of wimpy. But that's just my opinion. Obviously, we'll bring the verdict to you live when it comes in. Next on the docket, the wife of the accused Kentucky sheriff denies any relationship between the daughter and the slain judge. So, the spouse of a Kentucky sheriff charged with the fatal shooting of a district judge in his chambers has publicly refuted claims of any association between her daughter and the dead judge. Now, the Letcher County Sheriff, Sean Mickey Steins, remains in detention pending trial following the death of District Court Judge Kevin Mullins back in September of 2024. Now, there was surveillance footage purportedly depicts Steins discharging his weapon at Mullins during a private encounter in the judge's office, though Steins has entered a not guilty plea and asserts his innocence. I always think it's innocent we have to say allegedly or purports to show, oh no, when you watch the video, he shoots the judge, no doubt about it. You know, we got to give him the presumption of innocence. Now, speculation arose regarding Mullins' ties to Steins' underage daughter after her contact information was found in the judge's mobile phone. However, both the daughter and Steins' wife, Caroline, have categorically rejected these assertions. In statements to the Kentucky State Police investigators, they affirmed that no form of relationship existed between either of them and Mullins, who was married and had 2 children. Now, grand jury testimony from the state police detective Clayton Stamper confirmed that the minor had no interaction with Mullins through messaging, social platforms, telephone calls, or in any in-person meetings. Stamper noted, however, that the number was indeed present in Mullins' phone records, and he explained that Steins initiated a call to his daughter using Mullins' device shortly before the incident, as shown in the footage where Mullins hands over his phone. The recording does not indicate whether the call was answered, and no prior communications between Mullins and the girl were identified. And the court records initially released and later sealed after being acquired by a local newspaper there provided additional insights into Steins' condition post-incident. A medical evaluation from the Leslie County Detention Center on September 23rd of 2024 indicated that Steins exhibited signs of active psychosis in the days following the event. The report described him as disoriented, reliant on jail personnel for information, and unable to recall recent occurrences. On the day of the shooting, the courthouse was secured as law enforcement responded to reports of an active shooter threat, and Steins exited the building without interference, passing deputies who inquired about the perpetrator's location. According to Stamper's testimony, Steins appeared expressionless and did not respond immediately before eventually stating, "There's nobody else, it's me." He then surrendered his firearm and provided no further details. Subsequent investigations have uncovered troubling allegations against Mullins, including a witness account describing his office as operating inappropriately, with reports of intimate encounters occurring on site at the in Whitesburg, approximately 140 miles southwest of Lexington, Kentucky. Now, audio evidence that emerged months later suggests broader implications of misconduct extending beyond the courthouse and involving the local community. Steins and Mullum has maintained a strong, longstanding friendship, frequently dining together at a local sports bar. And on the day of the incident, they shared their customary meal of chicken wings and salad shortly before the confrontation. The timeline for Stein's murder trial remains undetermined, with prosecutors noting that evidence review may require additional time. And the now ex-sheriff Steins is currently being held without bond. And keep bringing it to you. Now, it's obviously interesting that, not interesting. Obviously, when the case first broke, there was allegations that there was something inappropriate. I think it's quite clear now that there was nothing inappropriate between Sheriff Stein's daughter and the judge, which is good because that's just weird and inappropriate for sure. But, let's face it, it would have made a much juicier story because right now we got nothing other than the sheriff shooting the judge in his chambers. At most, the potential lawsuits where Steins had to testify or give his deposition the day before, not as juicy as something inappropriate going on, but it didn't. So either way, we'll give Judge Steins the presumption of innocence, even though he did shoot him. The question is whether it was justified under the law. Next on the docket, what a shocking twist. Another married educator staring down prison time. Well, isn't this just a heartwarming tale of the year? A blissfully wedded schoolmarm, all of 37 years young, is now facing a luxurious 10-year vacation in the slammer after graciously admitting to some utterly charming interactions with not one, but two impressionable young scholars. Please meet Julie Riztello. Yes, that's the name of our exemplary role model, copped to a couple of those oh-so-minor second-degree sexual assault charges just last week. Now, this former educator, once entrusted with shaping young minds in high school English, apparently decided to expand her curriculum to include a variety of intimate extracurriculars, with her charges spanning multiple scenic spots in New Jersey. How adventurous. Anyway, prosecutors from Monmouth County, bless their diligent hearts, are pushing for a full decade of state-sponsored lodging for Miss Riztello, complete with lifelong sex offender registration and a permanent ban on ever gracing a classroom again. And if that weren't generous enough, they're tossing in eternal parole oversight beyond nothing, says rehabilitation like being watched for at least 15 years post-release. Mark your calendars. Her grand sentencing soiree is set for January 9th of 2026. Now, our heroine, who exchanged vows with her lucky spouse back in 2017, got hauled off to handcuffs last July, mere days after dramatically quitting her gig at the Wall Township High School. Sleuths pieced together that she'd been playing forbidden games with an 18-year-old protege from April to June of 2024. Oh, and let's not forget the encore performance with another underage admirer, featuring repeated romps between 2017 and 2018. Such dedication to her craft. Hired by the district way back in 2013, Riztello dazzled ninth graders with English lessons and SAT tips, all the while pocketing a modest $62,000 a year. She even moonlighted as a club advisor, truly the picture of community involvement. But alas, her stellar career hit a minor snag when authorities crashed her Brick Township abode on July 3rd, slapping on cuffs for her alleged student dalliances. According to the Boys in Blue, she bombarded one victim with risque selfies and a barrage of steamy texts. Their meetups? A whirlwind tour of Bricks, Belmar, and Wall Townships. The fun kicked off in April of 2024 with some light gratification, escalating to full-on encounters in May and June, including at least one memorable session in the kids' rides. Then there's victim number 2, who spilled about their cozy home visits in Brick from 2017 in November through January 2018. Detectives, ever the romantics, dug up incriminating pics and messages to back it all up. How thoughtful of her to leave a paper trail. The deeds of this ex-educator are nothing short of a profound stab in the back, not just to the poor kids involved, but to every trusting soul in the school system. Quipped the Wall Township top police officer Sean O'Halloran. Hats off to the brave souls who spoke up and to our tireless teams of nailing this one shut, keeping those kiddos safe. Yeah, that's kind of our jam, and we'll keep it to make sure creeps get what's coming to them for good for our fine citizens, the chief said. I just don't get it, ladies and gentlemen. These teachers, like I said, know what's gone on. No one's going to deny it. But what the heck is going on with all these female teachers? Usually it's the flavor of the month on the local news channels is male teacher. Maybe all the male teachers figured out that it's not good for you to be coaching, the girls' basketball team or the volleyball team and taking road trips. And they finally realized, maybe I don't need to coach the girls' team. But these female teachers, what are they doing? Bunch of 17, 18-year-old kids or even younger. Just not right. Just not right. And you know what's not right? Killing your wife in the car when you just, frankly, have had enough of her. So in Pekin, Illinois, police have charged a 93-year-old man by the name of James Pate with first-degree murder of his 80-year-old wife, Cheryl Pate, following a little incident in their car that took place on September 3rd. According to court records, the couple engaged in an argument while in their car, during which James Pate reportedly struck his wife before retrieving a knife from the center console and inflicting a fatal wound to her throat. He informed the police that he had acted out of overwhelming frustration, stating that he could, quote, not endure the situation any longer, end quote. The affidavit further indicates that the pair had been discussing divorce and accumulated resentment contributed to the outburst. Anyway, responding officers discovered James Pate at the scene with blood on his clothing. Cheryl Pate was located without a detectable pulse and was later declared dead at the local medical facility. A post-mortem examination conducted by the coroner determined that her death resulted from numerous sharp, blunt force traumas, which were deemed unsurvivable, aka stab wounds, slices. Not good, but he just couldn't take it anymore. Anyway, the district attorney has submitted a motion to prevent Mr. Pate's release from jail prior to trial, and details regarding the duration of the couple's marriage. Well, we don't know all the details, but apparently, if you're 93 and 80 respectively, and you're talking about divorce, there's a lot of resentment building up there. A lot. And when he says, I just couldn't take it anymore, can you imagine? The man is 93 years old and wants to spend his last days in prison, but he's probably thinking, worth it? No, it's not. The death of a human being is always wrong. But I mean, seriously, 93 years old to take out your wife? What are you thinking? My goodness. Next on the docket, this day in legal history, September 4th, 1781, Spanish settlers found Los Angeles, El Pueblo de Nuestra Señora la Reina de Los Angeles, establishing a legal settlement that would later integrate into the United States after a territorial war, after the Mexican-American War, where, we got California and Arizona and some New Mexico. To the victor goes the spoils, as they say. Next, September 4th, 1888, George Eastman receives a patent for the roll film camera, a pivotal moment in American intellectual property law and innovation protection. That's right, for all those youngsters out there, Eastman Kodak Company, ever heard of it? I think they're making their way back. People are going back to the old stuff. Go figure. No more digital. And then on September 4th, 1957, the Arkansas governor, Orville Fabus, called out state National Guard's troop to prevent federal court-ordered integration of black students into Central High School in Little Rock, Arkansas. President Eisenhower said, hold my beer, and then subsequently sent the United States 101st Airborne Division to Little Rock to enforce the court's ruling. I guess that's what happens when you're the president. You can call out the troops. Next, on September 4th, 2003, President George W. Bush signs the Prison Rape Elimination Act, known as the PREA, establishing federal standards to prevent sexual abuse in prisons and influencing correctional legal reforms. Now, you may laugh, but when you go into a detention facility, particularly a federal facility, there are signs all over about preventing prison rape. And now it's, back then, back in 2003, Now it's really illegal to do it. Next, our legal quote of the day. The purpose of the law is to prevent the strong always having their way. Who said that? Some guy by the name of Ovid back in 43 BC, ladies and gentlemen. So everybody always established that, when you become a civilized society, you have laws, you have rules. People need to follow them. If you're going to be a participant in the civilized society, you need to follow the rules. And if you can't, well, guess what? You basically get sent to jail. But before that, it was pretty much the strongest wins. And when you become a civilized society, it's not just who is the strongest and most powerful, but everybody should have the same protection. And finally, our dumb criminal of the day. Our dumb criminal, Rodney Plathey. Oh, bravo. In a world teeming with aspiring idiots, you've truly outdone yourself to claim the coveted title of dumb criminal of the day. How did he do it? Well, this 46-year-old registered sex offender, fresh out of prison, donning an inflatable puppy costume outside a Florida pet store because nothing says trustworthy employee quite like waving at passerbys while channeling your inner cartoon canine. And then, in a stroke of genius, you decide to escalate an ongoing dispute with some bike riding kids by waving them over, teaming up with your boss and, wait for it, sneak up from behind to chokehold one of them until they can't breathe. All the while, you're reeking of alcohol and refusing to chat with the police afterwards. Because clearly, what could go wrong with strangling a juvenile in broad daylight, in full view on a busy road, dressed as a dog? Your extensive rap sheet of batteries, burglaries, and that charming sexual battery conviction must make you so proud. Florida man strikes again, but honestly, even he might blush at the level of sheer, unadulterated stupidity. Congratulations on your felony arrest and that shiny no contact order. You've earned it, champ. All right, ladies and gentlemen, that's all we have for today. Hope you enjoyed the show. Have a wonderful day. We'll see you next time. And remember, the Constitution matters.